So, nice to meet everyone. I'm Katerina Licata. We met already in then maybe a few weeks ago. I was hosting a presentation on the disclosure package for pre-construction and the status certificate. Today, our attention will be focused on the assignment. So, I provide Sammy with these slides, but before going through these slides, I would like to review preliminary the form OREA 150, which is the form that you usually use for this assignment. So I will go back and I will show you that this is the OREA form 150, Schedule B. And then what is important for you to fill up in this form is Schedule A and Schedule B. I'm going back now with Schedule B, and we will see that it's a bit confusing. You are aware that an assignment occur when someone has already purchased and has already entered in an agreement of purchase and sale with the original seller, and then he doesn't have financial means, or he has other project and doesn't want to conclude the original agreement to purchase and sale, but wants to assign to someone else. This is frequently in pre-construction agreement when your client, the buyer, original buyer, which is the assignor, will purchase in pre-construction, and then there will be many years down the road to arrive to a final closing. In these 2-3 years, he may want to invest the money differently, or he may want to make his own money on the assignment, because an average of profits for an assignment is between 50,000 and 100,000 for condo unit, both in pre-construction. So the original buyer would like to find a second buyer and just to release himself from the original agreement of purchase and sale. The second buyer is the assignee. So we have 3 people involved: the assignor, the original buyer of the agreement and pre-construction; the assignee, which is the second buyer, the person who's going to is the second buyer who's going to assume the liabilities for the agreement of purchase and sale; and the original seller, which is the developer. So these 3 people are involved in this procedure. We have a first agreement, 150 REA form, signed between the assignor and the assignee, which is the agreement that you have to fill up as a real estate agent. And as I told you, the most important part is Schedule B and Schedule A. Then after we have a second agreement, which it will intercur after an average of 20 days from the execution of this agreement, which is the agreement between the developer, the assignor, and assignee. The developer has to consent to the assignment of the lease, okay, assignment of the agreement of purchase and sale. So we have the builder's execution consent agreement. And then we have the original agreement of purchase and sale, the original package that the assignor, the original buyer, got when he signed when he signed pre-construction at the pre-construction site. So what is important for you? Schedule B, it's important for you to fill up this form, which is a bit confusing. Don't worry about it. I'm just giving you an idea before starting my presentation, because at least you know what are the format that you have to use and you will face in this procedure. So this Schedule B, it's made up of point 1, 2, 3, 4, 5, 6. Point 1, you just have to write what? The original purchase price plus the assignment fee. I told you the profit is between 50,000, 100,000. So to the number 2, we have original purchase price here. You have to add here the original purchase price plus the assignment fee. So if I have a 500,000 original agreement of purchase and sale, and I want to have an assignment fee of 100, I will write here 600. Here, number 3, I have the deposit originally paid by the assignor to the developer. can be 100. What is the region deposit? The region deposit, payment for a locker, payment for upgrades. So you have to write here whatever the original assignor has already paid to the developer. Here, number 4, I have a payment by assignee to assignor for this agreement. How much is going to pay? This is incorrect. He's going to pay 100, the difference, plus the deposit, 184. 5, this is what has been paid for the assignment agreement, and this is the balance. Now, I go back here, and I will fill up this with you. This is my Schedule A, and here I'm going to fill up Schedule B with you. So this is important. First, I will put total purchase price, which is it. Original price plus the assignment fee. So we agree that if a number 2 original purchase price is 500,000, okay? And then here, I want to have an assignment fee for 100. Here I will write 600,000, okay? Number 3, the assignor's deposit to the developer. Everything, guys, locker, payment for locker, pay for occupancy, payment for everything, you put here. Can be 100,000, so I don't confuse you. Number 4 is what the assignee's payment for this assignment. Total amount. What is going to pay, guys? Is going to pay the deposit to the assignor, and is going to pay the difference here. So it's going to pay $200,000. Then number 5, I have the deposit for the assignment, okay? Whatever, you can put the 30,000, the deposit for the assignment. And number 6, I have the balance, okay? What is the balance, guys? The balance is 170,000. I go back. Schedule B. First, total purchase price is the original price plus assignment fees, 600,000. Number 2, original purchase price with the developer, 500. Assignor deposit to the developer, 100. Assignee payment for this assignment, deposit for the assignment, balance. This is Schedule B. Don't worry, I'm pretty sure you didn't understand, but I will go back. But at least you have an idea what we are talking. Then we have Schedule A. What I'm going to write in Schedule A. You have to fill up the form. You're going to write that the assignee agreed to deliver a certified check to the brokerage, okay? The assignee has to pay here $30 of deposit. So, and then in the Schedule A, you have to say that the assignee agreed to deliver the certified check in the amount of 30,000. You can break down, but this is not necessary. This is the most important clause for agent, the most important, guys. This one is the most important because what's going on and what's happening with agents. It's happening that agents in general, they have the opportunity to get their commission at the execution of the builder's consent agreement, or they have to wait the final closing. So we are in front of a pre-construction agreement of purchase and sale, and we have an occupancy date and a closing date. And I don't know if we are before the occupancy date or after the occupancy date, and then we may have to wait 1-2 years before the closing date. It's interest of the assignor, the first buyer, and both the real estate agent that the fees for this assignment shall be paid right away at this assignment stage. So what clause you want to write in Schedule A? The most important clause, the assignee and assignor agree for the brokerage to release the balance of the deposit to the assignor after paying real estate commission upon builder's execution of this assignment agreement. You want everything to be done at the execution of the consent of the assignment agreement. I explain you have Form 150 REA form. Then after the execution of this form, you will right away after the execution of this form, okay, someone is chatting with me. Sure, you have a copy of the Schedule A, not a problem, guys. So what about it's happening that you don't want to wait the closing date, but after the execution of the Form 150, the buyer's lawyer, the first buyer's lawyer, the assignor lawyer, will send an email, a request to the developer's lawyer to have the consent. The consent the consent assignment agreement. You will get it, your client will get it in 20, 30 days. This is usually the average, but this is not the rule, it's the average, but it's not the law. It can be less, it can be more. At the execution of this agreement, when the builders will give an agreement, they will explain what are his conditions to give the consent for the assignment. You will have the payment of the commission, and you have the payment of the balance of the assignment of this assignment agreement. So the balance, the pace of the balance shall be, so the balance of 170,000 shall be paid at the execution of the builder's consent agreement. So you walk away as an agent, the assignor walk away, and the assignee will pay then the final price at the closing day, at the final closing date. This is the most important. If it's confusing, ask me question, but I'm going forward with my presentation. Then you want to know here in the Schedule A, you want to write that the offer is conditional upon the assignor obtaining the official vendor's consent. Sure, it's very important that you write that the assignor has to get the consent, as well as that the assignor will pay the fees. Guys, there is a fees to get the builder's consent. The fees is between 5 to 50,000. 5 to 50,000. And then practically, you will see that you want to add another clause. The assignee acknowledges the assignor has purchased the property by way of prior agreement of purchase and sale. Sure, it's important that you put in Schedule A that your agreement, the 150 REA form, is conditional upon the assignor provide the original agreement of purchase and sale with all the attachment, all the disclosure package, and all the breakdown of the fees to the assignee within 5 business days. It's important that the assignee knows what is the original contract, where are the duties, the responsibilities, the liabilities, if there is still a cap on the statement of adjustment. He has to review with his lawyer. So this is an important condition. Then you want to write that the contract, the Form REA 150 is conditional upon obtaining financing. Why? You don't care as a assignor. You really don't care if he can pay the final. You don't care at this stage that he will pay the final price. You care absolutely, but not at this stage. But it's important to get the builder's consent agreement, because I'm pretty sure, and this happens always, the builder's consent agreement will request the proof of financing for the next assignee. So you want to anticipate this request of 1 month, and you want to put the REA 150 conditional upon the assignee obtaining financing, because you don't want to waste your time, and then after 1 month the builders will ask and the assignee cannot provide, and so you are wasting 1 month of your time. So here is important that the assignee acknowledge that the assignor is assuming all the liabilities of the original agreement of purchase and sale, but the assignor has to guarantee that the original agreement is in good standing. His right has not to be assigned to third people, and he has been in compliance with all his obligations. So you want to know what is the breakdown of the original deposit, the original payment done by the assignor to the assignee. So within 5 business days, you ask again a copy of the breakdown of the original payment. Then it's important that you will write this, that the offer is conditional upon the approval of the terms by the assignee solicitor as well as the assignor. This is important for an agent because you want to avoid any liabilities. Then this is the trouble clause, because it's the HST. So your Form REA 150 doesn't say anything, but you should be aware that in each pre-construction agreement, you will see that the developer will take responsibility for HST rebate only for the first buyer, for the assignor. But for the assignee, he doesn't take care of it. And the assignee has to apply directly to CRA. So in order to apply directly to CRA, your client, if he's the assignee, the second buyer, has to know that at the final closing, he has to pay the HST, even if he's entitled to a rebate, and then he will get the rebate directly to CRA. Then who's paying the HST on the assignment fee? You're fully aware it's the assignor who's paying the fees on the assignment fee. Before I was telling the HST on the final purchase price. The HST on the final purchase price should be paid by the assignee, and the assignee will not be entitled to the rebate with the developer, has to apply direct to CRA. Then what is important then identification, is important the indemnification agreement, because if I'm the senior, I want to be sure that I will be indemnified. And then if I'm the assignee, I want to be sure that I will have my clarification as well. This is the most important part for the agent, that you are asking, you write in Schedule A that you are advising the client, assignor and assignee, to get professional advice. So you are trying to exempt yourself from certain liabilities. There's a Schedule A and Schedule B. Don't worry, I'm pretty sure you didn't understand anything. So I'm going back to the presentation now. Okay, I'm going to the presentation, and now we can start the argument. So what is an assignment? We saw that the assignment occurs only when an original buyer of a pre-construction agreement want to assign his rights to another buyer and then walk away from a deal. We know that he can make a profit between 50,000 to 100,000, and then we are aware that 3 people will be involved. It's necessary that everyone is necessary that the developer's consent as well. So here we see a party, okay, the assignor, the original buyer, transfer benefits, right, interest under the agreement to an assignee, second buyer. The assignment should be written. So we have a form OREA 150 is the form that you are going to sign with your client. And then you will see that, and then there will be the second agreement, which will be the builder's consent agreement, which will be provided by the builder's lawyer. So what we have, and this is the first problem we face, the original agreement of purchase and sale most probably will stipulate that the purchaser cannot assign, is prohibited to assign his agreement with, or, and then you may find an amendment that the same, it's possible, the purchase has the right at a certain condition. One condition is the prior written consent of the vendor. And then another condition for sure is the proof of financing of the assignee. Third condition is that fees. The fees will be between 5,000 to 15,000 paid to the developer. So when you are going to review an original agreement to purchase and sale with your client, you may want to negotiate right away originally the fees for the assignment agreement. You want to decrease, because if tomorrow your client wants to assign the agreement, he wants to make a profit. And then if the profits is 50,000, you have to deduct 15,000 to be paid to the developers for his consent. So you have to make this, or the execution on the form 150, you may ask the assignee to be responsible for the payment of the fees. Usually is the assignor, but you want to phase in Schedule A that who will be responsible to pay the fees for the consent of the developer's consent to the assignment. Then you're fully aware, if you have been going through assignment, you're aware that original assignment agreement to purchase and sale prohibited the purchaser to make an assignment, because the developer is concerned that these people will buy the condo, will assign, and then he may lose his right to sell. So he will put for sure a clause that until 95% of the condos are sold, nobody can assign. Be careful as an agent, there will be for sure a prohibition to advertise the assignment of a condo until that percentage is not reached, will be reached. Then we have this amazing vendor consent. As I told you, the fees and everything. You have to be fully aware that sometimes the builder's consent agreement is in contrast with what you have been writing in Schedule A, Form 150, and or may add certain concern that, for example, happened to me lately, like 1 month ago, that in one there was an assignment, and it was, I found a very strange clause. I was representing the assignee, and I found a strange clause that the agent for the assignor wants the assignee to accept this assignment absolutely without any consideration of the builder's consent agreement. And I was shocked because I understood that something was going on there. Why? Because then I spoke with the agent, and the problem was that the builder's consent agreement was imposing a condition, like the original cap on the statement of adjustment was going to be removed if in case of assignment. It means when you sign the pre-construction agreement as original buyer, assignor, you may want to negotiate the cap on adjustment, development fee, the development fees, levy charge fees, and blah blah. But the builders with the developer will request that this cap stays only if there will not be an assignment. So if the assignee will be provided within 5 business days from the execution of the original offer or the original documentation, and then you will see that there are a lot of cap on the statement of adjustment, okay? So he will make a certain consideration about the final purchase price. And then when he will get after 20, 30 days, the builder's consent agreement to review, he will see that that cap were removed in his case. This is one. But then there are other conditions. The developer, for example, in his agreement can ask an additional fee, an additional deposit, which maybe the assignee is not ready to pay at the execution of at the conclusion of this assignment agreement. It will happen that the assignee will walk away and you will lose the assignment. So the assignee should be, the assignor should be aware. So the IHST rebate, as I told you, and the IHST rebate on the final purchase price will not be considered at the closing date. So if you represent the assignee, you have to inform him that he will not get the rebate at the closing date, but he can apply directly to CRA. If you represent the assignor, you have to inform the assignor that the HST on the assignment fee shall be paid by himself. You can clarify in Schedule A, but these are the rules. Then here, the builder's agreement, and then here the price. I'm going back, okay? I'm going back to review the original agreement. That's the price. I show you Schedule B. Schedule B, we have a total purchase price, which is the original purchase price plus the assignment fee. I have number 2, which is the purchase price of the original agreement of purchase and sale. And then I have number 3, the deposit paid assignor to the seller. Number 4, payment by assignee for the full amount. This is incorrect. Then 5, the deposit paid for the assignment fee. For the assignment agreement, 6 is the balance. I show you here, we went through and we did together, the Schedule B. So I wrote Schedule B, original purchase, the total purchase price, which is the original purchase price. This one, 500,000 is the original purchase price plus assignment fee. We put 100,000. So it's 500 plus 100 is 600,000. Number 3, I will pay that. I will write the deposit, whatever the assignor has been paid to the developer. Be careful. In Schedule A, Schedule B, if you represent the assignee, you have to request that the assignor breakdown for whatever payments made already to the developer. Okay, I want to know what this 100,000 means. It's payment for locker, it's payment for occupancy fee, for what? Then I have number 4. Assignment payment. This is what the assignee is paying for this assignment. Why 200,000, guys? He has to refund the assignor for the payments already made, and he has to pay the assignor for the assignment fee. And then the deposit for the assignment can be 30, 40, up to you, and the balance. We know this is the most important thing. You should write in Schedule A, the balance for this assignment agreement shall be paid in full at the execution of the builder's consent agreement. In 1 month, you want to walk away, you want to cash your commission, and if you represented the assignor, you may want him to have enough money to make another investment. So you close an assignment and you go right away to make another investment for himself. Then, so this is Schedule B, the price. Then I go back to the to my presentation, and we already faced the problem of HST. I told you already how does it work. HST on assignment fee shall be paid by the assignor, original buyer, and then assignee on the HST rebate should be paid on the final purchase price should be paid at the closing date by the assignee. It's important that the assignee shall know the exact terms of the original agreement of purchase and sale. So I already explained to you, it's better in Schedule A that you will write within 5 business days, the assignor shall provide the assignee, all the original agreement of purchase and sale, original disclosure package, original breakdown of the payments already made, upgrades, payment of lockers, whatever. So the in 5 business days, the assignee will can review it and make his own decision, because you have a review from like we saw already in Schedule A. You will write that the assignee has the right to review the agreement with his solicitor. So you will give 10 business days. It's too much. This timing is too much. Usually the execution of the assignment agreement, within the 2 business days, the assignor will provide the original package, and within 3-4 business days, the assignee's lawyer will review the same with the assignee. The terms are shorter than what I told before. So here I explained already the financing, why it's important. I'm the assignor, I really don't care, but at the execution of, regarding, as far as the builder's consent agreement concerned, you have to be fully aware that the assignee has to provide the proof of financing. I'm developer, I'm not going to change one client with another one if I see that the second one is not capable to pay the purchase price, right? And because you want to avoid to waste 1 month of time, because after 20-30 days from the execution of the ORE agreement, you may get the developer's consent agreement, and at that time you have to provide these documents. So it's better to ask in advance. So you may write in Schedule A, within 5 business days, the assignee shall provide proof of financing. Then we go here, the following slides. You want to know that the assignee, and the new that the assignor is making his own representation and warranties. What is important? Well, I'm selling, so as assignor, I have to guarantee that the new home agreement of purchase and sale is valid and good standing, that I'm not in default in the performance of any obligation, there is no right of set-off a counterclaim, and I have not assigned my rights under the agreement to a third parties. So these 3 points are important. So in Schedule A, if you represent the assignee or the assignor, you may want these 3 statements to be added and initialized by the assignor. The assignor and the vendor should confirm the purchase price. So as I told you, the vendor, I told you that already, the vendor may add additional deposit in his consent agreement, and then the assignee may be forced to pay additional amount of money, so be careful about it. Then what's happening about the termination? What is the problem with the termination, guys? Exists because in reality, everything can go well, but when something happens, we try to find who's the responsible one. So if I'm the assignor, I will try to walk away and to be released from any liabilities. This is not going to happen. Only once I saw in a developer's consent agreement that the original assignor was released from of any liabilities or responsibilities. But in general, the developer doesn't want the assignor to be released. He wants to add to the assignee liabilities even the assignor, in the sense that if for example, the assignee is not able to close, he wants the assignor to be responsible as well. So what can happen? You may want to add in Schedule A that the assignor, that if you represent the assignee shall provide, if you represent the assignor, sorry, the assignee shall provide an indemnification agreement to the assignor. It means if something happened, the assignee the assignee will indemnify and save harmless the assignor from any liabilities, claims, and blah, blah, blah. If you represent the assignee, you may want the same from the assignor. But then what is it when this payment adjustment, then land transfer tax will be paid by the assignee at the closing date. So at the assignment stage, nobody cares about the LTT, the land transfer tax. It will be responsibilities. What we should care is the Tyrion warranties. Why? You are fully aware that these warranties start from 30 days from the occupancy date. So what's going on? If I will take possession tomorrow, okay? In 30 days, I have to submit a 30 days a year form with the Tyrion warranty. With the Tyrion warranty, and then I have to compare what is written in the report, in the PDI report, and what deficiency has been complied already by the developer and what is outstanding. So if I'm the assignor, I should care in 30 days to submit a 30 years end form where I'm going to report all the outstanding deficiencies. Why? Because if I'm the assignee and then I know that the assignor took already possession, I will want for sure a copy of the PDI, and I want a copy of the 30 days year form. I want to see if the original buyer take care of this. Otherwise, I may ask even discount. I may ask a discount, I may walk away. Who knows about it? So I explain again, maybe the concept can be more difficult. When I take possession of a condo, after 30 days, I have to submit a 30 days year form with Tyrion warranty. And I have to report all the deficiency outstanding. Before occupancy, I will get a PDI from the developer. So I will compare what's it's written in the PDI, what are the deficiency outstanding, what has been complied with, and then I'm going to report the outstanding one in the 30 days year form. So if I'm the assignee, I want to see that this has been done properly by the assignor, and I don't want to incur indeficiencies, and maybe I have to pay more additional deposit additional amount of money in order to recover these problems inside the condo. So then what it's important to know? IGST rebate, I told you, IGST and the rebate. So now I can go back and I can see wonderful Schedule B. This is my wonderful Schedule B from 150. Here I put the total purchase price, original plus assignment. Here the original price. Here the deposit paid by the assignor to the seller. Here the payment, total payment by the assignee to the assignor, which is made up of the deposit plus assignment fee. Here, whatever deposit is, and the balance. So I'm going back and I'm going back to my Schedule A and my Schedule B. My Schedule B is this: purchase price, assignor deposit to the developer, assignee payment for assignment, deposit for the assignment, balance, that. And I'm going to Schedule A. The assignee shall deliver a bank draft in the amount of, this is the deposit payable to the brokerage. You can break down the assignment, you don't care. This is the most important clause for agent. The assignee and the assignor agree for the brokerage to release the balance after pay the real estate commission and upon the execution, the builder's execution consent of this assignment agreement. You may want for sure write that the final balance of this assignment shall be paid at the execution of the builder's consent assignment agreement. if you represent the assignee or the assignee, you have to write the offer is conditional upon the assignee obtaining the vendor's consent. Who's going to pay the fees? Usually it's the assignee, but you may want to negotiate. There is no rule. So it's better you face this problem when you are writing a Schedule A, because maybe your client then down the road, there will be discussion. So you want to be sure the assignee is going to pay the 5,000, 50,000 of consent fee. Then you want to write that the assignee acknowledge that he's going to accept that the assignee has purchased the property by an original agreement of purchase and sale, and you want to be sure that the assignee will get the full package within 2 business days from the execution of this agreement. So Schedule A, the assignee within 2 business days, the assignee shall obtain from the assignee, the assignee shall deliver to the assignee the original purchase price agreement with all the amendment and then disclosure package and the breakdown of the payments already made. Then you want to be sure that assignee warranties that the original agreement of purchase and sale is in good standing, his rights has not been assigned to third parties, and that he is in compliance with all the payments made. You want to be sure, and you want to be sure that the offer is conditional upon approval of the terms by the assignee solicitor as well as assignee solicitor. This is our important clause for you. You want to inform the assignee is not going to get the rebate at the closing, assignment at the closing date, but he has to apply with CRA. And you want to be sure that assignee shall pay the HST on the assignment fees. You're right or not, is the assignee responsible. And you want to be sure there are indemnification agreement for the assignee and the assignee. And especially this is a general clause important for you. The parties agree that to release the funds, and the assignee acknowledge that the listing is suggested to seek professional advice. Okay, so now I prefer to interact with each one of you because I have been explaining, generally speaking, what is an assignment, but I want to know who has done an assignment and what problems he has faced, so we can talk about it and I can clarify better. It means, guys, someone of you has to unmute. I have 50 people. You want me to pick up 51 of the 50? No, I don't think so. So, but has someone done an assignment agreement? I see Christina that is unmute. No. Has someone done an assignment agreement? Look, I'm here just to review this with you, to be sure you understand and to be sure that you're capable to do a Schedule A and Schedule B, to cash your money ASAP and to not have any trouble in the presentation, in drafting the agreement or the clauses. So I can, for sure, I will give clauses to everyone who needs it, but now that you have the opportunity to ask me question, take advantage of it. I'm pretty sure someone of you has already done an assignment agreement, and I'm pretty sure it went to trouble. The first time is challenging for everyone. So what do? I pick up someone, or I just wait someone that will be unmute and will ask me question? Don't be shy, guys.
Hi, Katerina.
Hi.
Hi, it's Ida. Okay, so sometimes the most confusing part is at the end, the client doesn't know how much is the total cost, that they have to pay. So, but the builders, they cannot disclose it. Sometimes, oh, we don't know, the final amount. They will never tell you the final amount, So I just want to know, let's say, how can we tell the client how much they can prepare with the, let's say, development levies, the hookup charges, or whatever. So where can I, or how can we get like a kind of like a ballpark amount to tell the client how much they should come up with at the end?
First, if it's the assignee, you're fully aware he's not entitled to HST rebate. So there is another amount of money to consider. Then you have to go through the original agreement of purchase and sale, and you will see the original purchase price and approximately the cap on the statement of adjustment. I saw that the developers always maintain the cap in the statement of adjustment. So you will see the cap like 9,000 can be development fees, charges, or other stuff. Honestly, when I did my originally, I was always told that 50,000 more. I was always told calculate always 50,000 more because there's land transfer tax and there's adjustment, and it was correct, guys. I was it's not the correct amount, perfect amount to say, but it was approximately what I had to pay. So because at that time I cannot tell you at the assignment stage what will be the final price, and then even the assignor seller, the assignor's lawyer is going to prepare a statement of adjustment, but that one is only for the assignment, is not for the final purchase price. And even if you ask the developer to provide an SOA, he will not provide. He will provide the 10 business days before the closing, the final closing. So you can make a calculation according to the original agreement of purchase and sale. You can easily calculate the land transfer tax, and you can easily, and you can have an idea of 20, 30,000 more on the purchase price.
Okay, so let's say at the end, the assignee, they say, oh, wow, I didn't expect I have to pay this much. So at the end, any cases you've dealt with before, and what are the remedies?
For this price, I never got to the final purchase price. I never. Even if I was close to the closing date, I never got it, the final purchase price. It means I didn't get it, the SOA from the developer's lawyer, I didn't. I just got the SOA from the assignor's lawyer regarding the assignment fees, with all the breakdown and with all the payment done, the assignment fee, original purchase price, and whatever. You will not get it, the final SOA, you will not get at the assignment stage. You can make roughly a calculation, an average. You can review the agreement of purchase and sale. You can say what is the original purchase price, and you can see if there are still cap on it for the statement of adjustment. Like development fees, if there is a cap of 6,000, 8,000, if it was removed. You can make a calculation of the land transfer tax right away.
Okay, thank you.
It happens to me just once, honestly, that one client walked away from an assignment because he didn't know if the rebate, the HST rebate was going to pay at the it was going to be calculated at the final closing. And then this was clarified even by a written email by the developer's lawyer that he was not going to get the rebate at the final closing, and then he didn't want to wait to apply for CRA. He walked away from the deal. This is what happened to me. For the rest, like you always are aware when you are purchasing pre-construction, it's difficult that you get the final SOA. I always get 10 days before the final closing.
Okay, so the proper procedure is we both the so me, let's say if I'm representing the assignee, and I will like negotiate the offer and everything with the assignor's agent, and then after everything is, let's say they accepted it, then we put like we put all these conditions subject to lawyers review and approval, whatever, and then before we send it to you, right? And then how many days would you suggest we put on the offer saying that, well, it's for lawyers review? So how many days you actually need after we have already negotiated the offer?
2 business days.
2 business days for you, and then, but also the builder has to accept it,
no,
right?
That one you cannot put it. You have to write, because if you represent the assignee, there is a clause in Schedule A that you have to write that if that builder's consent will not be provided within 30 days from the execution of this agreement, the assignment agreement will be void, and then the assignee deposit shall be returned in full without any deduction. This is perfectly correct, because the builders can even take 2 months, who knows, but at least you are writing a termination. But the average is 20 business days for the builders to provide his consent agreement. Just one
Okay.
page, guys. It's 1.5 pages.
Okay, thank you.
Don't forget to click the count box.
Oh, who has done an assignment? Someone else has done an assignment already?
Hi, Katerina.
Hi, nice to meet you.
Hi, this is Jessica. I have done assignment deal before. I just wonder, do you have a clause to specific saying the assignor will be responsible for the HST for the assignment part?
This is the rule, okay? Because he's getting the money, so he has to pay the HST. You just write the assignor shall pay the HST on the assignment fee. This is it, straightforward. But if you represent the assignee, you may want to write.
Yes, because usually, like last deal, I represent the assignee. So on the purchase agreement, we specifically say the assignor will be responsible for the HST for the assignment deal, and the assignee will be responsible for the HST rebate, the transactions after, the assignment deal, like upon the final closing. So just wonder, do you have a good clause to specifically saying that?
It's honestly is this one here for the HST. Can you see it?
Yes.
The assignee
okay.
acknowledge that he shall be responsible for the maintenance HST due on closing. Cuni is reduced charge by the vendor in the final settlement adjustment. The assignee shall be responsible of his expenses to apply for HST rebate after closing with CRA, and the assignee makes no representation with respect to HST for this transaction. The assignee indemnify release the assignee for any liabilities. This is the clause for the assignee. It's complete for the assignee. Here, if the assignment of agreement is subject to taxes, then such taxes shall be included in the assignment price. Any applicable taxes raised from in connection with the profit shall be the responsibility of the assignor. So here you have the two clauses. Can you see it?
Okay. Yes, I can see it.
You have
Okay.
here.
Thank you.
So, who has been dealing with assignment still? Okay, so you can talk. Like there are many people, maybe they have not done assignment, so it's better you know how does it work. I'm here to answer every question. I'm available absolutely, even through email or phone call or whatever. Not a problem. You are dealing with drafting an assignment agreement. I can easily review right away. If I can help you out, and for me, it's not so complicated. It takes a few minutes. But here you have the time just to review with me these things. Any other question? Last time, no one could add the question. This time, is the topic more difficult, guys? It's technical, and I may understand. If you want, I can go back and review Schedule A and Schedule B. Just tell me, let me know.
Hi, I just wonder when you get the agreement to review, will you be able to estimate the final adjustment, like including the levy and all those like costs? Will you be able to estimate?
An estimate, which is not the final one.
So, like, would that be like when we tell our client that maybe 10%, 9% of the purchase price, would that be, you think that would be feasible?
No, because you don't know. First of all, you have to see if there are upgrades, if the original buyer added upgrades, if he added locker, parking. So to the original purchase price, you have to consider all these additional payments. And plus, you got to go to the statement of adjustment, and you will see if there are cap. If there are cap, you can approximately estimate. If there are no cap, you can just say to the client what he can expect, and that he's not going to have HST rebate at the final closing. So he has to add that amount of money. These are the consideration. Upgrades, locker, parking, if land transfer tax, like you want to see if there is if there are cap on the adjustment on the different items in the original agreement of purchase and sale, which they should remain after the assignment as well. So you may make a calculation, a roughly calculation,
Okay.
but not the exact one.
Okay. Thank you.
Nothing. What other question? You have to
Carolina,
get
I got a question.
Yeah.
So in the just on the screen, the first page, you have that clause regarding the balance of the deposit. So as like if we represent a assignee, right? So would that be a concern if for the buyer, the assignee, buy the new contract, but if something happened to the builder, then the final deal cannot close, and even the deposit, everything already paid. The deal is not fulfilled in the last. So would that be a concern for the assignee?
So if I'm correct, and then I can tell you one problem that I'm incurring now. So your concern is that maybe I didn't understand well the question, that the assignee will not pay the final purchase price. But you know that the assignee already refunded the assignor of all his payments and expenses. The problem is that the assignor can be on a hook as well, because the builders doesn't release the assignor. Usually he doesn't release, so the agreement can go back again to the assignor to be complete, and then the assignor may be responsible. So we wrote the clause Schedule A that the assignor will receive an indemnification agreement executed by the assignee. But for sure, the assignor is still always responsible until the end. Because
I guess what I mean is the concern of the assignee in case the builder for the project not finally fulfilled.
yes,
And,
if the builders doesn't complete the project, is this the question? It's if it doesn't complete the project, well, you have to consider that the assignee, in fact, the assignee can ask an indemnification agreement from the assignor. I wrote already, there is a schedule in Schedule A. You can write a clause that the assignee will ask an indemnification from the assignor if the builders will not complete the project. If I'm the assignee and the assignor is asking me an indemnification to protect himself, I will ask him back an indemnification agreement to protect myself if the builders is not going to close the deal. But you have to write this agreement with the assignor.
so should be put into like an additional clause into the Schedule A, so that in case the builder cannot complete the project, and everything will be can be like go back.
Here I wrote, the assignor undertakes to indemnify and save assignee harmless from any all damages arising out of the assignor failure. And then as well, assignors wants to have the opposite. So it depends. The assignor can be from one way, and then the assignee and then they say harmless the assignor eventually from any and all damages arising out of his failure. And the assignee, you can change. So the assignee may reasonably require in order to effectively carry this assignment agreement and sale from the vendor. But you may add, so you can have two clauses. One, the assignor undertakes to indemnify and save the assignee harmless from any damages arising out of his failure to do acts and things. and he will as well as from the builders. So you will add here as well as from the builder. You will add here and execute the documentation required to carry out this agreement. And you can change the clause and put assignor and assignee.
Mm-hmm.
Right? This is the same clause. You just play the game. You put it twice, and the same vice versa is from the assignee. Is from the assignor to the assignee. I personally will write a clause like that, because if the assignor will try to write an agreement where he will be released from the assignee, but I will not. If I'm the assignee, I will not sign any release, full and final release for the assignor. Absolutely, I will let him stay on a hook until the end, as well as the builders will do the same. So they're all three responsible.
Mm-hmm.
What happened to me is something different since lately. I had an assignment, and honestly, like the guy is it's a strange assignment. Like the guy assigned the assignment, but in reality, the assignment date is after the conclusion of the original agreement of purchase and sale. So for example, that the final closing is February 15, I have the assignment closing March 15. And then it was totally different because in this case, you don't need the consent from the developers, because in reality, you're going to be owner of the same in 15 days. And now apparently the developer is postponing the closing. So when you're in front of this more complex case, you should add many clauses that relate your contract to the previous agreement of purchase and sale. I don't know if I'm clear about it.
Yeah, I think I get the idea. Thank you.
And always, guys, copy of PDI. Copies of PDIs and copies of current warranties. The forms 30 days form submitted with current warranty shall be provided with the full package within 2 business days from the execution of the 150 REA form. There's someone else who wants to ask a question?
So Katerina,
Yes.
continue with that question. Say, for example, if the project was canceled before the final closing, so is there any clause we can make sure the assignee will be able to get the profit payment to the assignor back?
You can add an indemnification agreement. You can add this clause, the clause I show you, that the assignor undertakes and agree to indemnify the assignee from damages arising out of his failure to comply with the agreement, as well as the builder's failure to complete the agreement of purchase and sale.
Right, but
you may ask.
Yeah, but if anything happened, shall we still go through like a legal process, like go to the court in order to get the deposit back?
You know,
because I know for the because original for the original deposit, I know is under the protection of Tarion. However, for the part you paid to the assignor for the profit part, I guess there's no any like protection for that part of money, right?
No. You can sign an indemnification agreement. You put as a condition, you want the indemnification as a condition of the agreement. You want the indemnification agreement to be executed by the parties.
So you need to add another separate schedule or agreement?
A schedule, a clause in Schedule A.
Okay, just to add the clause in the Schedule A will be good enough to cover that?
Yeah, because then the lawyer will prepare the indemnification agreement.
Okay, I see.
You just add the clause that the assignor undertake to indemnify, but then the lawyer shall prepare the indemnification agreement.
Oh, okay, I see. Thank you.
For nothing. You just face the problem in Schedule A, so the assignor has to sign the indemnification agreement. There is no way, because he already agreed. So then the lawyer will take care of prepare the same.
Okay, sounds good.
Other question? Here you are all very active, so I'm willing to answer and to reply to any question you may have. Have 50 people in front of me approximately, right? Oh, 40, we go down to 40. Time is expiring, so we go down 40. So guys, someone else, did someone deal with this assignment or not?
Sorry, what are the fees, the legal fees for the doing assignment?
The legal fees?
Yeah, your fees.
$700 is not more. This is a, but usually we prepare even the schedule A, schedule B sometimes. Like the agent come to me and then we prepare the agreement as well. These are the fees, no more.
Okay, thank you.
Then the client stays with us for the final closing if he's the assignee.
So hi, is the fee including the interim closing and the final closing as well?
No, the fee is for the assignment.
Okay.
Then you have to be careful at what stage your client is purchasing the property, if it's before occupancy or after, because there are additional fees to be paid at the occupancy date. And remember, in the timing between the occupancy day and the day your client will take possession, their occupancy payment to be made. That one is responsibility of the original assignor. If the occupancy occurred January 15, the assignment will be closed February 28. The occupancy fees from January 15 to February 28 will be paid by the assignor, because he's enjoying the place, so it's not included in the assignment fees until you will consider, like until you will face this issue, and you will face these issues in the original agreement.
Okay, question. If the original assignor, he actually is overseas. So if I found an assignee here, so can you do this like so let's say if you're representing the assignor for the overseas one, can you just do it electronic signature, or how do you do this?
You will use DocSign.
Just DocuSign, right? You can do that, right?
We do DocSign.
Okay, that's great. Thank you.
It's not a problem.
Hi, I just have a question about the assignment fee. See, if the original price like $500,000, you as your representation, and there's a assignment fee like $100,000. Does it include the builder as the assignment fee? Like some builder is like a one-time free, some builder ask like $5,000 assignment fee.
You have to write in Schedule A that the assignor is responsible for the payment of the builder's consent fees.
Oh, I see.
Right.
Okay. Yeah. So you write the assignment fee. It's just the perfect assignor got from the second buyer. Is that correct?
Yes, but if you write in Schedule A that the assignor shall pay the consent fees, the 100,000 will be inclusive of the assignor HST payment as well as of the vendor's consent fees. So be aware how much are the consent fee for the developer, because your client wants to make 50,000 in his pocket, and in reality he wants to make 60,000, 50,000 in his pocket, but the builder's consent fee is 15,000. So then when he has to pay the consent fee, his payment will be cut off or cut down. So you may want to face this problem in drafting a correct Schedule A. It
Okay.
means that the assignee shall be responsible for the consent fee. You negotiate, okay? You negotiate. You represent the assignee, or you are negotiating with the assignee. The assignee say, you know what, for the assignment fees, I will not give you more than 50,000. Your client say, not a problem, but you will pay the consent fees for the development, for the developer. The fees for the developer's consent, which you know that is 15,000, for example.
Mm-hmm.
So you
Okay.
already take your 50,000 out of the pocket.
Okay. Thank you.
Okay. So what other are the other question? Look, don't be shy. If I'm here to answer questions. So really, really don't be shy. Ask me, because now I'm here. Tomorrow, nobody, Sammy's busy, another one can be busy, and then you have to face the issue right away, and you don't want to make mistake. So I'm fine to continue to answer your question. And I'm seeing here people still are present. It means that they are interested in the argument. So I have a shy question. Okay, the problem for HST rebate, guys, you can even write directly to me if you feel shy. So the question is, who's going to pay the HST rebate? The HST rebate shall be paid by the assignee at the closing date. You are not going to negotiate this with the assignor. So you write or you don't write in Schedule A, doesn't matter. But what you want to be sure is that the assignee is fully aware that the HST rebate at the closing date will not be paid, will not be guaranteed, but he has to apply directly to CRA to get it. So if the assignee is entitled to 20,000, 24,000 HST rebate, he has to pay that amount of money to the developer. The developer has to pay CRA, and then he can ask back the developer to just the CRA, sorry, Canada Revenue Agency, to refund his HST rebate. So the HST rebate, the assignee will get it. At the closing date, he has to advance. Perfect. Right, you can chat with me and I will reply to your question, guys. So
one question is, typically who is the assignee's agent going to prepare the agreement? As a node?
what did you say, sorry?
Whose agent going to prepare the APS?
Both agents. Usually I'm involved because the agent asked me to help them out, but the first agent will make an offer. But before I have never seen, honestly, in my experience, an agent who will sign right away an offer for an assignment, and then the other party will execute. I always see that the party they collaborate in the assignment. I see a lot of collaboration within the two agents. The most important thing, so guys, is your commission. What I'm always seeing every time an agent does his first assignment agreement, the first mistake, and he will never forget for the rest of his life, is that he's not going to get his commission right away. What does it mean? You have to write that the commission will be the deposit paid to the brokerage shall be released after the payment of the commission at the execution of the builder's consent agreement. It means, and the balance, the 170,000 we were talking before, the balance of the assignment fee shall be paid in full at the execution of the builder's consent agreement. This is the most important, because you're an agent, you want to make your money right away. You really don't want to wait 2 years, 3 years down the road to take back your money for the commission. So this is the most important thing. Then what also, like, you please write a solicitor's review. And then it's important that the other party will provide the full package. The assignor has to provide the assignee right away, the full package, the full agreement of purchase and sale with all attachment and amendment, and then the breakdown of the payments already made to the developer, and then the PDI form. You will be very considerate by your client if you are explaining them that a copy of the PDI and a copy of the Tyrant warranty report shall be provided, because you appear very knowledgeable in front of your client. Is that okay, Alec? Am I correct? You can just chat. You can just reply. If I have not been clear, please let me know. Thank you for terrific. I like the comment. Thank you, Alex. What other question is there outstanding for me? So there's another question outstanding for me. You can adjust the type on the chat. We are still here. It means everyone wants to know, but in reality, no one other people have not the courage to ask me questions.
Sorry, one more question, Catalina. So I know that after the assignor has made a profit, so so they're supposed to report that income on the income tax returns, right?
Mm-hmm.
And then yeah. And then let's say for overseas buyer, okay, so so do they just I don't know, they get the certificate of the clearance certificate, and then the next year they still have to report the tax, or like how does it work?
They have to pay to CRA.
Yeah,
they
pay.
Report it to CRA.
You mean
if they don't prepare? Yeah, if they don't if they have to report the same to CRA.
And just do it once, right? So even like after they did the clearance certificate, the next year they still report that to CRA, right?
They have to pay the HST to CRA. It's not just to report, they have to pay the HST on the assignment fee. 100,000 is the HST fee. So they have to pay that to CRA directly. Because here we don't have the developer who's collecting the HST for the client. Here we have two people, so the assignor is going to make a profit, so he has to pay the HST to CRA directly.
Okay.
If he doesn't live here, if he doesn't have to fill up an income tax return and everything, he has to pay the HST to the developer.
Yeah. Okay.
To the CRA, sorry.
Yeah. Okay. Thank you.
Hi, I have a question. Yeah. So when we drafted the agreement for assignment, does the assignment fee most often includes the HST, or do we charge it on top of that to the assignee, or?
Inclusive.
Inclusive, okay.
Usually it's inclusive.
How about the development charge? I think I missed that.
The problem is that at the assignment stage, we don't know what will be the final SOA from the developer's lawyer.
Okay, so that amount will be, should be charged to the assignee. at the end of closing, at the final closing, for the development charge, levy, or hookup fee. Is that correct?
Yes, at the final closing.
Okay, makes sense.
At the final closing. So we were talking how we can fix it, but we can do an estimate, but not the final. The developer's lawyer will not provide us with a statement of adjustment at all.
Okay.
So we can just go through the agreement of purchase and sale, calculate the land transfer tax and everything, but not the correct final SOA. That one, you get it 10 days before the final closing.
Makes sense. Thank you.
Be careful if you represent the assignee, be careful. You have to tell him that he will not get the rebate at the closing date. Hello? I have been clear with this explanation for the assignment. I tried to touch the argument several times, so at least you have an idea of the agreements to be used and everything else. I think if I wait, someone else will ask me questions still. Guys, there is someone else who had problem with assignment. Maybe something was not clear in the presentation. Let me know. You're welcome. You're welcome, Michael. Guys, you have something else to ask? Last time you were so aggressive in the questioning for the disclosure package, status certificate. You were so excited. This time, what is the assignment is more difficult? You want me to terminate the meeting? I can terminate if there are no other questions. You're welcome, Ida. I left with Sammy some depliants because we do incorporation for agent at a lower price, like $700. We do the incorporation for agents, inclusive of the disbursement for the government. So, which is approximately more than $500. So Sammy has that. He welcomes Sly. Sam has it that thanks, but you can contact. Sam has that the plan. So if you may need it, because I know the agent can incorporate, so we provide incorporation for agent as well. Ida, I think that Sammy has a copy of the presentation, and I think he posted a copy here in the chat, guys. There is a click. You can click and you can download the presentation. With regard to the, 1 second, you may want this from me. You share. You want this eventually. I share on this actually. Also, 1 second. I think can you? Okay. I want this eventually, which is schedule A. I don't know if in the chat I can pass. Yeah, I think I can pass in the chat. No, it doesn't come. It doesn't come. But as a file, we see if as a file I can download presentation. I'm trying just to give you close. No, it doesn't go. It doesn't go through. However, who wants the schedule A, they can just email to me. I will provide to everyone. My email address is Katerina. I will try to provide the Sammy as well with a copy of the schedule A. Okay. So if you want someone, like I will try, you can just email, I will provide schedule A, and I will provide a copy of schedule A to Sammy. Oh. Can you still hear me? Yes. So guys, if you have other questions, please. I'm here to continue to answer as many as you want. I will try to send me them send me the clause. And you can don't be shy. You can easily ask me when you are. You can easily ask me when you are doing when you are preparing an agreement. You can just ask me I'm sending the email to Sammy regarding Schedule A, and then when you are facing the problem of assignment, you can just text me, ask me. I'm available for you guys. So here I have. You're welcome, Ida. You're welcome, Rita. You're welcome, everyone. So, guys, if you don't have other question, I will, with the Semi permission, I will terminate the meetings. But I'm available to answer, to still continue to answer your question. And Semi has my schedule. He has the Schedule A, and I think you can easily ask to him as well. Okay. So, guys, I will.
Okay. Thank you. Thank you, Catalina.
You're welcome, Sammy. Thanks for the opportunity to you.
Okay, no problem.
It's always my pleasure.
We have our agent. We have any problem, they can feel free to email you, and hope you can get a WeChat later. We can contact with you used by WeChat.
Yeah, with our WeChat, yes.
Okay.
It's our condition now. This WeChat. Yes, I will do my WeChat. I will do, and I will add you.
All right. Okay. Thank you. Maybe we'll see you next time.
Thanks a lot.
Yeah.
Thank you.
Okay.
Bye.
Yeah.